answering any questions. The way the presentation will go today is I'm going to take the first 30 minutes to go through the slides and information, and then maybe answer some questions. And then Elena will take it over to go a little bit more in depth around the eviction process and what that all entails, especially since that seems to be a very concerning, looming thing for a lot of people, and I would imagine for a lot of people that you all are working with as well. So I won't take up more time. I'll go ahead and get started on the presentations. Feel free to type in your questions in the chat, and we'll try to get to them as best we can. Okay, so we're going to start really broad. I call this presentation from move in to move out type of presentation. So as I mentioned, I'm going to breeze through some of this information. Let's see. So when you're applying for an apartment, you know, there's a couple of things that you want to know, and just things to be able to protect yourselves or the people that you work with. Make sure that you get copies of all the applications and the receipts for any fees that you might have paid, just so that you know, according to the law, there's an application fee that is usually charged. And just so that people know that it is tied to an indice in the stock market called the Consumer Price Index, and right now it's about at $50 maximum per person that's over 18 years of age. Another great thing to know that most people don't know is that according to the Fair Credit Reporting Act, if you get denied any type of service or anything like that that's based on your credit, you have the right to request a copy of your credit report. So most of the fees that are charged for applications are to run your credit and to screen you as a tenant. So if you get denied the apartment that you're looking to rent, then you can always ask for a copy of your credit report just to make sure that they actually use the money that they charged you to do that. So then let's say you get into a lease. There's different types of leases. There's a fixed term lease. There's a month-to-month, which is probably the most common. And then there's also written versus oral leases. A fixed term lease is probably the safest bet if you can get into a fixed term lease, because it offers you the most protections. There's one thing to note on a fixed term lease is read in the contract whether or not it will automatically convert in month to month. Some leases at the end of the term, like usually a year, it will go month to month automatically and does not have to be renewed. But if it doesn't state that it goes month to month automatically, then you will have to be concerned about renewing the lease or moving out, and then also negotiating with the property owner to do that. Month to month is just as it suggests. You pay every month, and it can be terminated at any point with proper notification. And then there's the oral lease. Those, according to the law, are legally binding, but they're just a lot more difficult to defend. And we know a lot of folks that get into verbal contracts, and we just always recommend that you try to get them written in some way, shape, or form, and try to avoid just relying on a verbal agreement, because if things go sour and you have to try to defend it, it's much harder to do. So always ask the folks that you're working with or yourself, whether or not you have a written contract. Other things, I know that myself and probably a lot of the in-home care workers work with people that speak another language other than English, and it should be noted that that the law does allow for the request of the contract to be in the language of their choice, and so you can always make that request that the contract be given in a different language, especially prior to signing, so that so that they know what they're signing. And also, if people don't have a copy of their lease, they should always have a copy of their lease. If they don't, the law does allow folks to request a copy of their lease, usually one time per year, and the property owner or the manager is required to provide a copy of that lease within 15 days of it being requested. And when you request the copy, you can also request it in a different language. These are just a couple of things that you should know, some terms that that are usually included in a lease. I'll just gloss over that because you can look at that later. And then, so let's say you get the apartment and you're moving in, right? So you want to do a move-in inspection, and usually the management does this with you. But if they don't, we always recommend that you do it on your own. There's checklists online that you can Google, very easy, and this is just sort of how to do that, right? It's like make a list of all the damages and repairs, take pictures of everything, print the pictures and the list, sign and date it, make copies, and then send it to the management or the property owner via certified mail, so that you have a record of the condition that the apartment was in when you moved in. And this is good to help protect your security deposit later on down the line when you move out. And talking about security deposits. So security deposits are very common. They're usually paid at the beginning of a lease. Usually it's like the first month's rent plus a security deposit, and those are two different fees. So don't confuse the two. Included in the security deposit should cover like key deposits, any cleaning fees that are required at the end of the tenancy, processing fees, and the pet deposit. I know a lot of property owners that charge a pet deposit and a security deposit, but they're not considered separate or different. They're considered the same deposit. They're supposed to be included together, and this will come into play in the next slide. So the amounts of the security deposits for unfurnished apartments, they're legally allowed to charge you up to 2 months of the monthly rent, and for furnished apartments up to 3 times the monthly rent. Those aren't as common. Security deposits can be increased as long as they're not violating the 2 times the monthly rent, the amount allowed. So, but they just have to give you proper notice. A lot of people don't know this, but yeah, security deposits can be increased. So in order to protect your security deposit at the end of the lease, do a move-in checklist, give proper notice that you're going to move out, which is usually 30 days or based on your lease, and schedule a move-out inspection before the actual move-out date. So as I said, the pet deposit and the security deposit should be the same together. They should not be more than what's allowed by law, which is the 2 times or the 3 times the monthly rent. So security deposits must be refunded or accounted for within 21 days after moving out. So either they give you the deposit back minus any fees, but they have to give you an itemized list as to what those fees are and what they went to. And they have 21 days to do this after you move out. So it's not required that they return the security deposit right away. If the security deposit is not returned, you can write a letter requesting that it does get returned or it gets itemized, or you can take them to small claims court. So let's go over rent and other payments, some information. Rent payments is usually due as per the contract. Late charges is a question that we get a lot. The late charges usually are not negotiated upon signing the contract, and they're supposed to be, because late charges have to be a reasonable estimate of the costs that are incurred because the payment is late. So it cannot be punitive. They cannot punish you for paying the rent late. It has to be justified. So for example, I'm a property owner and I depend on my tenant's rent in order to pay my mortgage. If I don't pay my mortgage, then I get a late fee on my mortgage, and then I can then pass that late fee on to my tenant because I have a late fee due to their non-payment. That is a justified late fee. A punitive late fee is just because you paid your rent late and I want to charge you money. and that's not allowed. So just something to know. And partial payments usually don't have to be accepted. The landlord cannot require cash or cannot require online payments, and a tenant should always get a receipt, no matter what. Utilities, I'm going to gloss over this real quick. It's just usually it's stated in the contract, and California does not regulate how landlord bill tenants for water and other utilities, so just be cautious about that. This is an area that we get a lot of questions on, habitability. I guess in some that the landlord is supposed to give you a healthy and safe place to live. The unspoken contract is, I give you my money and you give me a healthy place and safe place to live. And if they're not holding up to their end of the bargain, then they have to fix stuff that needs to be fixed. And this is a list of some of the things that apartments should be free from. So this is a lot of instructions as to how to get repairs done, but basically we recommend document. I know if you all are in the service industry, you know about this. If it's not written, it doesn't exist. So we suggest that tenants try to do as much documentation as necessary. We recommend communicating in letter as opposed to text and verbally. It's just it's safer that way if it ever needs to be defended. Usually a reasonable time in waiting for repairs depends on the actual repair that is needed, but the state says 30 days is usually typical amount of time. But if it's an emergency, it doesn't have to wait for 30 days. If you make requests for repairs and they don't do it, you have other options. You can call the county health department or the city health department, the city code enforcement, or any other housing agency in the city that might be able to help with getting those repairs done. The law affords you two choices if repairs are still not done. As long as you let the property owner know what your intention is, you can either do what's called a repair and deduct, meaning that you can make the repairs yourself and then deduct it from the rent, or you can withhold rent 100%. Again, you just have to let the landlord know with enough time, which is usually 30 days, that this is your intention after already having made several attempts to try to get them to fix things. The other option is you can always make the repairs and try to sue the landlord in small claims court as well. The law states that if you request repairs and the landlord tries to raise your rent or evict you within 100 days, 80 days of making those requests, that's considered retaliation, and it's against the law. We, as organizers, we always say that it's safer to do it together. So if it's a building that is experienced with multiple tenants experiencing issues, write a letter collectively. Write one letter addressing all the issues in all the units, and it's more effective that way. It's more protective, and it's safer for the tenants so that they don't have to be singled out. Rent increases, this is also common. There's some nuances here because of new laws, but technically and generally, if the rent increase is less than 10% of the rental amount, they only have to give you 30 days notice. If it's more than 10% of the rental amount, they have to give you 60-day notice. There was new laws that was passed in January called the Tenant Protection Act, AB 1482. And most apartments and rental units are covered by this, but there are some exemptions. So you first have to determine whether or not your building falls under the new law. And if the unit does fall under the new law, then rents cannot be increased more than 5% plus the consumer price index, which is the rate of inflation. And right now the consumer price index, because of the economy, is really, really low. So like in LA County, it's on average around 5.7 to like 6%, depending on where you live. So rents right now, legally, if you're covered by this new law, cannot be increased more than that. Rent increases have to be in writing. They have to be delivered to you properly. They have to have all the correct information, like the correct date and the amount. And the time starts of the notice from the time that you receive the notice. So if they give you a 30-day notice, they can't give you a backdated notice for like 5 days. It starts from the time that you receive the notice. So just make a note of when you actually get the notice and when the notice is dated. So notices, these are some things that you might see with some of your clients or with yourself. If you're given a notice to vacate, if you've lived in the unit for less than a year, it has to be 30 days notice. If you've lived in the unit more than a year, it's 60 days. 90 days notices are usually for homes that are in foreclosure or like Section 8 or other government subsidized properties. Again, with any notices that you're provided, it has to be in writing, has to be delivered properly, has to have all the correct information. And if it doesn't, then it might be deemed insufficient, and that might buy you some more time. Under the new law, AB 1482, if you are covered by 1482, the Tenant Protection Act, you cannot be evicted for no reason. You have to be given a reason. This is a new thing. Before, property owners can evict you and not have to tell you why. Now, if you're covered by this new law, they have to give you a valid reason. And some of the reasons that are allowed are written in the law. There's like 4 reasons that are at no fault of the tenant, and those are usually like if an owner wants to move in an immediate family member, if they're going to do substantial renovations to the unit, if they're going to take the property off of the rental market, and then there's a 4th one that I can't recall, but we'll get to. But they're in the slides so that you would be able to refer to that. We are seeing a lot of illegal lockouts and utility terminations, and Elena is going to go into the actual like eviction process so that you understand what an illegal lockout is. But it is illegal for property owners to turn off utility services. It is illegal for them to prevent the tenant from gaining access to the property, like changing the locks or blocking entrances. If that happens, I mean, there's damages that a tenant can pursue. They take a lot of time. They take some time, but I mean, there are lawsuits that a tenant can file if this is the case. If the tenant feels comfortable, they can call the local police department and try to get the local police department to get the landlord to let them back in to the unit. Or they can seek legal advice, legal counsel, and try to file what's called an injunctive relief to try to force the landlord to let the tenant back into the unit. There's 3 days notices, 3-day notice to pay rent or quit. This means if you haven't paid rent, you got to pay or you got to go. To cure or quit is usually if you violated something on the lease or the house rules. A notice to quit is just because you did something that violated the lease that is incurable, according to the landlord, and they just give you 3-day notice to move out. 3 days do not include holidays and or weekends. Also, another common notice is notice to enter. A property owner cannot enter the unit without 24 hours notice, unless it's an emergency, or the tenant moved out or abandoned, or there was agreed upon with the property owner to get into the unit. The landlord must give the tenant reasonable advance notice in writing, and it has to be in writing. It cannot be verbal. It cannot be via text. Especially now with COVID and people sheltering in place and quarantining, this is an issue that has come up a lot. And if somebody is sick or ill or in fear of being infected to COVID, they can make reasonable accommodations requests, and for the landlord to not enter or to make sure that the tenant is not in the unit when they need to come in. Another notice is if there's a change in ownership, they're required to let you know. So that covers most of the general presentations. I wanted to open it up for any questions right now, if anybody has any questions, and then I'll turn it over to Elena to talk about the actual eviction process.
Hi, Jorge. We haven't had any questions in the chat box thus far, but if anyone has any, please go ahead and put those in before we give it over to Elena.
Okay, well then, before we give it over to Elena, I'll go over a couple of slides. So let me see, I wanted to go over this part here. Things to know. Oh, good question. So how can someone find out if a building is protected under AB 1482? There's usually sort of like a diagram. Tenants Together has an actual toolkit that you can go on our website and find. It's at tenantstogether.org. And it's an AB 1482 toolkit, and it basically it's like a flow chart. It asks you questions, and then it guides you to the next question to determine whether or not that unit is covered by AB 1482. There's some nuances and some exemptions, and it can get confusing. So the flow chart really helps people to determine what those are. With the current rent moratorium, I think it is moratorium, there are no evictions, correct? If so, given a 3-day notice, what should a tenant do? Well, generally speaking, there are eviction protections, which Elena is going to get into. We are suggesting, because as it stands right now, today, this might change in a couple of weeks, and hopefully it doesn't. The courts are not processing any evictions, and so it is our recommendation that tenants just stay in place, even if they're given a notice to don't move, to stay home, right, until they're legally removed from the unit or have that ability to do so. So whether it's a 3-day notice or a 30-day notice or any kind of notice, we're suggesting that folks just shelter in place and stay in place. And then again, like Elena will go over the eviction process, and then she'll explain why it's safe to do. All right. How can a tenant find out if late fee is justified or not? That's a good question. Maybe I'll leave that to Elena to answer. I mean, I would write a letter inquiring for the justification, just to have that documentation that it was requested. So, but maybe Elena has more legal ways of finding that out. How do you know if you're in a rent protected unit? Like if you're, I am assuming that question is if you're under rent control, or if the unit is under rent control. There's a website, I know there's a website where you can type in your address to see if your unit is under rent control. AB 1482, again, the toolkit would help you determine if you're covered by 1482. If you are covered by 1482, then you do have a rent cap of 5.76% right now. And that's another type of rent protection. It's not considered rent control like in the city of Los Angeles or in other cities. Yeah, Elena Popp, she put in the chat, it's called Own It. Own It is the website that you can type in your address to determine whether or not it is under rent control. I think it's ownit.org. Let's see.
I think the only other question was, how can a tenant find out if a late fee is justified or not?
Again, that one I would say I would probably write a letter to the landlord, and you cannot be evicted. And correct me if I'm wrong, Elena, but as I understand it, you cannot be evicted for non-payment of the late fee, although they'll try. tenant laws and like rental laws are kind of like speed limits. You know, the speed limit is 65. The law says you can't drive over 65. Doesn't mean people are not going to drive over 65. And tenant landlord law is kind of like the same. Like, this is what the law says, but whether or not the landlord actually abides by the law is a totally different story. Even though the law says this stuff, this is for the tenant to be able to advocate for themselves and to protect themselves if they have to go to court, but it does not prevent the landlord from doing stuff that they're not supposed to do. Lockouts are illegal unless you go to court, but we are seeing more and more of them happen because landlords just, they're trying to get away with it, and they think, and in some circumstances they do. So with the late fees, the same thing. They have to justify the late fee, and because people don't know that it's negotiable, they don't usually question it. So I would write a letter asking, you know, why this amount of late fee? What's the justification? What's the financial impact if I pay my rent late? And then go that way. How do I know if I'm Section 8? I think was.
So the answer to the late fee question is that late fees are supposed to not be punitive. They're supposed to be reasonably calculated to compensate the owner for the cost of serving a 3-day notice and collecting that late fee. So we have a case that says $25 is okay. We have a case that says $50 probably isn't, but that's a very old case. So really it's, was it bargained for? Was it negotiated? And it's very vague. A late fee cannot be demanded in a 3-day notice to pay rent or quit, but it can be demanded in a 3-day notice to cure covenant of your agreement by paying this late fee or quit. And so tenants often have to face the decision of paying the late fee or risking eviction. My advice when people come to us before an eviction has been filed is pay the late fee and sue in small claims, because that's easier and safer. My advice when people come to us after an eviction has been filed is, let's go forward and prove that this is an illegal charge. So the advice changes depending on when we are in the process. If we can avoid an eviction, then we will by paying the late fee and suing in small claims. Should I take some of these other ones quickly? Did I? Am I still muted?
No, go. You're still. I can hear you.
Okay.
Yeah, there's some good questions. Like there's the one about, I have a family, they're not paying their rent. The owner has stopped paying the mortgage. How long can they continue to live in the unit?
I'm going to answer that in my presentation. So if folks could keep their questions focused to what Jorge talked about, then I will make a presentation. And if you have questions about my presentation, I will answer them then.
Yeah, there's a question here, how to determine if a landlord is receiving government benefits under Section 8. So there's two ways of getting Section 8 subsidized housing. One is it's focused on the property. So like usually senior housing, there are some low-income housing buildings that are getting government subsidies to be able to offer low rent. That stays with the building. It does not stay with the tenant. So if the tenant moved from that building to another unit, then they may not get Section 8 or subsidized assistance in that other like building. But then there's Section 8 vouchers, where that actually goes with the tenant. So the tenant should know whether or not they are getting Section 8 rental assistance or not. To determine whether or not a building is actually getting subsidized housing, one indication is that the rents are low and they're intended for low income, and that people are only paying 30% of their income toward the rent. That is like one key indication that that building is subsidized by the government. If that's not the case and you still want to find out, I think the low income, the national NILHC, the National Income
National Low Income Housing, not National Low Income Housing Coalition.
Yeah, National Low Income Housing Coalition. Their website might have some resources on how you might be able to determine whether or not that building is. There's also an organization called SCANPH, SCANPH. You can contact them, and they can also help you determine whether or not that building is receiving subsidies. In Los Angeles, there's another organization, the Coalition for Economic Survival, CES. They work with a lot of subsidized housing in the city of Los Angeles. They would also be able to help you determine whether or not the building is under Section 8 or receiving subsidies. Is the landlord obligated to add a person to the lease? If so, is there a maximum dollar amount? No, landlord is not obligated to add a person to the lease. There's no maximum dollar amount. I'm assuming that question is based on the rent. Yeah.
So actually, it's the jurisdiction the tenant lives in. The law is different in each of the 88 cities in LA.
Okay.
If a tenant lives in a rent stabilized unit, what people call rent control, then that local law determines what under what circumstances someone can be added to the lease. So in the city of Los Angeles, for instance, a tenant cannot be evicted for replacing a tenant or for adding one additional adult occupant to the lease that is above the original number in the lease, and the landlord can charge 10%. A tenant can't be evicted for adding up to 2 children, 2 additional children born in the unit. The first one is free, multiple births are free. The second child, the second birth is 10%. But each law is different. I'm not sure what the Tenant Protection Act says. And otherwise, if there is no rent stabilization law that protects the unit, the landlord is not obligated to add a person to the lease, and the amount they can charge is whatever the landlord and the tenant negotiate.
Yeah, and in LA County right now, because of the eviction protections that they have, additional occupants, if they're covered under the LA County ordinance, additional occupants in the unit is not a reason for them to be evicted. But that's a temporary law right now in LA County due to COVID, and so we have yet to see if that's going to be permanent. Before I turn it over, I just want to say this, because I'm an organizer, and so I always try to advocate for tenants to fight and to challenge notices, to don't move out with notices if they're unjustified. And I try to let people know, it's like, look, only because the landlord takes you to eviction court, it does not mean that your credit is going to be ruined. It does not allow them to lock you out. It does not allow them to throw out your things. The police and the sheriff cannot do anything to you until you go to court. And that is actually sort of like the results of going to court. So only going through the eviction process does not do any of these things. So if the tenant believes that they're being unjustly evicted or forced out, I tell them it's like to fight, because it gives them a chance to stay in their home, and it's not going to ruin any of their credit like they're always told that they're going to do. We hear landlords threatening tenants all the time. I'm gonna report you to the police. I'm gonna ruin your credit. I'm gonna do this. But they cannot do any of that legally unless they go to court and lose. So I tell tenants, fight, go through the process, get an attorney, because there's usually a favorable outcome when that happens. So that's what I do. So with that, I'll turn it over to Elena.
Okay, show my screen. Can you see my screen?
Yes, I can, but I just see where it says connected to go-to training. Okay, I see that you're pulling up your PowerPoint.
Okay, great. So I'm Elena Popp from the Eviction Defense Network, as indicated previously. And one of the concerns that I always have when we do these presentations is that we give you just enough information to be a little dangerous. Because, you know, the training that I have took me 35 years to get. And so it's important that you understand that what we're giving you is ways to spot issues and the resources or locations where you can get help. This is our general tenant do's and don'ts. Jorge went through some of these. When you move in, read and understand what you sign. When you move out, give a 30 days notice. Don't sign anything you don't understand. Never sign a lease with, never sign any of these without a lawyer, an estoppel certificate, or a voluntary vacate agreement. Do take pictures and document the condition of the unit when you're moving in and when you're moving out. Pay the rent on time, never in cash, get valid receipts. We advise people to join tenant organizations. We should add Tenants Together. Is Tenants Together on here? We'll add Tenants Together to this. It's actually an older document that we're not using right now. And always work with a lawyer when you are facing any kind of legal problem. When the very first thing people need to determine when someone is being given some sort of information or advice is what law applies, okay? Because every unit is governed by a different set of laws. So these are the questions that you have to ask. Number one, is there a rent subsidy? Why does that matter? Because if there's a rent subsidy, you're in the federal laws and the federal regulations, and that's the law that applies. The second question, if there's no rent subsidy, is there a local tenant protection law? Many people call these rent control laws. That's just our laziness. It's like when instead of saying copy machine, we say Xerox machine, because we're from the generation that the first copy machine was the Xerox. There are no rent control laws anywhere in the state of California. Why not? A rent control law protects three things. It protects the rent. When can the rent be raised? By how much? It protects amenities such as a laundry room, a swimming pool, a jacuzzi, a backyard area, things that are not essential to health and safety, but you got when you first moved in. They can't just be taken away. Usually they can be taken away if you're compensated with a rent reduction. And then the third thing they protect is reasons for eviction. They all have a different but similar set of reasons. In order to qualify as a rent control law, then when the tenant moves out, either because they were evicted or because they moved out voluntarily, the next tenant steps into the place of the old tenant. The rent stays the same. That's what rent control means. In 1996, the state legislature passed a law called Costa-Hawkins. That law prohibited rent control laws, and they all became rent stabilization laws. A rent stabilization law protects the tenant that's in the unit, but it doesn't protect the unit. When a tenant moves out, except for some exceptions, but generally when a tenant moves out, the next tenant pays market rent, whatever the landlord can get. That's why there's so much harassment, because the landlord is seeking to evict the current tenant so they can raise the rent to market. There are local tenant protection laws in Baldwin Park, Beverly Hills, Culver City, Glendale, but that one is eviction protections only. It does not protect amenities, and it does not protect the rent level. So in order to evict a tenant, all you have to do is take away their parking or raise the rent $1,000, then you can evict them for non-payment of rent. There's also rent stabilization laws in Inglewood, Los Angeles, Santa Monica, West Hollywood, and unincorporated county. And I don't, so many people in LA County don't know. I'm going to go over this in a minute, but this is a map of the county. The little inset is the same as this on the outside. There are 88 cities in LA County. The city of Los Angeles is the biggest one, and it is in red on this map. And then all these little gray areas are separate incorporated cities within the county. And then we have unincorporated LA County, which is all the white areas. And you'll see there's a little white area there, and one there, and one there, and one there, and one there. So there's all these unincorporated areas. And the laws are different in each of these 88 cities or in unincorporated counties. So you have to know where you live. Early on in the pandemic, I would get these messages on this Facebook group that I facilitate. My landlord is evicting me. I sent him this letter. I told him the mayor of Los Angeles says bloody bloody. Well, dude, you live in Pomona. So what the mayor of Los Angeles says has nothing to do with the laws that protect you. Not only do we have this layer of rent control protections, but we also have what people are calling moratoria. And I'm going to talk about those in a minute. It's really the subject of the next session, but I know it's what is on people's minds. So we're going to talk about the moratoria in big quotes, because they are not moratoria, in just a minute. And the ones that what protects you is also dependent on where you live in each of these places. So in terms of rent control laws, the first thing you need to know is this unit in a city that has a law? And then the next thing you have to know is, does that law protect this particular unit? Each law has a definition. So in the city of Los Angeles, for instance, what the law says is every unit in the city of Los Angeles is protected except, and then it has 10 exceptions. And so the unit has to be built before October of 1978. Why? Because developers say when we fight for rent control, if you pass this law, we will never build again. So new construction generally gets exempted. Under the TPA, we did a rolling date. The unit has to be at least 15 years old. In Los Angeles, we did a set date, October of 1978. Why? Because we got smarter over the course of those years between October of 1978 and now, and decided we really need a rolling date. In Los Angeles, single family homes are exempted. In Santa Monica, I think 4 units or more are exempted if the owner lives there. So you have to look at the particular law to see whether that unit is protected. If the unit is not protected, then you ask, is it protected by the TPA? The Tenant Protection Act applies if the unit is not otherwise protected, and if it is more than 15 years old, except it doesn't cover single family homes and condominiums, unless that single family home and condominium or condominium is owned by a corporate entity. It also does not protect the duplex if the owner lives in one of the 2 units. And single family homes in general don't protect things like board and care facilities, medical beds, student housing, or that kind of a thing, or government subsidized housing. And then the last thing you need to ask is there a written rental agreement? Because whatever the law is, the rental agreement might have some protection that is not in the law, not usually, but it could. Or whatever the law is, the rental agreement may be trying to circumvent that law or cut that law, and you need to know what that rental agreement is saying. Where is it? Oh, there we go. This is the eviction process. Evictions start with a notice. It can be a 3-day notice, a 5-day notice, a 10-day notice, a 20-day notice, a 130-day notice, a 16-day notice. It can be of any length. And they usually either say quit, because you don't have any right to be here, or cure or quit. Pay the rent or quit. Stop, get rid of that little pet that you have that violates the contract or quit. Get rid of those extra occupants or quit because you've been such a problem that you can't be here because you're a nuisance. If you don't do what that notice says to do within the number of days in the notice, the landlord can file what we call a summons and complaint. Backing up, during the COVID crisis, in some jurisdictions in LA County, including the city of LA and all of unincorporated county, and any of the 88 cities that doesn't have its own laws, and this also applies to mobile home residents if your local law doesn't include the mobile home in it. Those people cannot be evicted for violating their lease if they have an unauthorized pet or extra occupants, just during the crisis, okay? And during the crisis, we have something called Rule 1 that is going to be talked about next time. Rule 1 is the Judicial Councils, a very little known body that administers our courts statewide, passed a rule saying that a local jurisdiction cannot issue a summons. And I'm going to explain why that's important next time, but I'm going to give you a teaser this time. After the notice expires, legally, the tenant cannot be evicted. Legally, the only thing that can happen is the filing and service of a complaint. A complaint is exactly what it sounds like. It's the landlord complaining about your behavior and telling the court why that warrants kicking you out. And then you have to file an answer. An answer is your side of the story. Why shouldn't I be kicked out? Again, during the crisis, because a summons is not being issued, the tenant should not file an answer because the court has no jurisdiction over them. If the tenant files an answer, the court gets jurisdiction, and then the lawsuit can move forward and you can get evicted. But during the crisis, as long as Rule 1 is in effect, don't file an answer. This is a typical complaint. It's a judicial council form. The judicial council is the administrative body that runs our courts. It's designed to make it easy for people, for landlords. It's part of the let's make it easy for people that represent themselves to represent themselves by giving them check the box forms. In fact, I'm aware, and I'll end in 5 minutes. Actually in 3 minutes.
Thank you.
But this is what the complaint looks like. You don't need to know what this looks like other than to recognize it, because when you get someone that's got this, you're going to get them to us at the numbers I put in my chat, how you get people to us through either Ask an Attorney or our hotline. The summons, which isn't being issued right now, but can be printed off of the court's website, and some landlords are trying to be tricky and serving summonses that have not been issued by the court, looks like this, and it explains to the tenant in very small print what they have to do. This is a notice of unlawful detainer or notice of eviction. This is a courtesy notice that gets sent out to the tenants, telling them that they have 5 days to file an answer after they get the summons. Because right now they're not issuing summonses, they're also not issuing these notices. But when they start issuing summonses again, they will start issuing these notices. This is the form in Spanish. The other forms don't exist in Spanish. You could also see something that looks like this on top of an eviction packet. It's called a prejudgment claim of right to possession. It's a message to any tenant whose name is not listed right here under defendant. If you want to defend this action, file this as well. And sometimes they put it on top. So if you get a summons and a complaint and you don't answer, a default judgment gets entered, and then you get a notice to vacate 14 to 21 days. If you answer, then a trial gets set, a whole bunch of stuff happens here, and then we have an 89% win-loss rate at trial, and we have a 98% overall success rate, and so people should get help. This is an answer, a sample. This is another sample answer. This is done on pleading paper. Either one works. And again, the process. People often ask about motions to quash service. That means they think they didn't get properly served. We don't do them because they're a waste of time. Throughout the process, there's something called discovery. Discovery is both sides' opportunity to find out what you got on each other. The lawyers do that. I'm going to skip motion for summary judgment. This is a notice to vacate. This is the notice that the sheriff puts on the door, letting you know this is your deadline. That they can come as early in this case as the 26th, and generally they come 3, 4, 5, 6, 7 days later. But right now they're coming right on the following day. Why? Because they're just starting to evict people this week, so they don't have a backlog. After they evict you, they put this on the door and you cannot enter again. I already talked a little bit about rent control, so I'm going to skip this. Less than 1% of tenants that go to court alone without a lawyer are successful. Please get people to us. We have funding from the county to represent people right now. Evictions have horrible results: displacement, instability, bad rental records, a debt to the owner that accrues interest at 10% plus huge penalties. So we want to avoid these scenes of displacement. We want to keep people in place. In terms of COVID, I'm going to say the following. We were expecting 365,000 evictions in April. We got 500 and something. And in May, 200 and something. And in June, 300 and something. And in a normal pre-COVID year, our average is 3,300 per month. And the reason for that is this Rule 1. So the summons cannot be issued. Landlords are not bothering to file eviction summonses. But we are in danger, so it stopped this eviction tsunami, but we are in danger of losing Rule 1. And the reason we are in danger of losing Rule 1 is that the Judicial Council has announced that it may lift it on the 14th. I'm going to put an action alert in the chat that I think folks should do. I'm not even sure if that's appropriate with this group, but we are going to see 365,000 evictions in LA County alone if we are not successful. And hence, I think it is essential that folks do this. Questions? We have 1 minute.
They're wanting to know what your number is to call.
Put that in the chat at 9:28. My contact info is there. Please don't use my cell phone number or my email unless you're calling about organizing. If you're calling about organizing, happy to talk to you. Otherwise, use our intake system. We have 3 webinars a week, every Tuesday, every Thursday, every Saturday. The links are there. For intake, you send an email to askanattorney@edn.la. We also have a digital divide hotline. Other questions? Were there any other questions in the chat, folks?
There's one about the webinar links in the chat.
Yeah, what about them?
If you can place them in the chat.
They're in the chat. The webinar links are in the chat. They're in the chat at about 9 o'clock. I can put them in the chat again. This is the action alert to save Rule 1. It is the most important thing anybody can do today and every day. Every day, usually at 9, today I'll do it at noon. I call all of the people on here and tell them a story of a client that I talked to the day before to tell them why they should do this. I will put the contact information again in the chat. Sorry, this is so rushed. I will, anything else, any other questions that you see, Jorge?
Just another question about a family whose owner has stopped paying the mortgage. Well, if the family, I think if the family is unable to pay rent, then all they have to do right now is send in a letter letting them know that they can't pay rent due to COVID.
Yeah, I will also put, I will make sure you all get what we call the tenant survival guide. It has sample letters. If you send an email to ask an attorney, you get that automatically. So remember, they're in the same boat as 4.3 million other people in the state of California. They're in the same boat as between 365 and 600,000 other families. This is not an uncommon problem right now. That family cannot be evicted. The case cannot even be started as long as Rule 1 is in effect. We are fighting for, we have some local eviction defense protections, and we are fighting for stronger protection. But that family, you know, right, it should go to one of those webinars so that we can tell them this a little bit more calmly. And then usually you have to say it and say it and say it and say it and say it, and then you say it again, and they're still worried about getting evicted, because it's natural for people to feel concerned about an eviction action when they haven't paid their rent. So you have to do a lot of reassuring. But right now, people are saved. And these are the webinars again. Right now, people are safe, and they will be safe as long as we keep Rule 1. So please help us save Rule 1. And here is our intake information again. Edit copy.
I'm sorry to interrupt, Elena. We have to jump on to the next one. The next.
I'm going to put one more resource, people. COVID-19 tenants rights hashtag on every fridge is the Facebook group that somebody asked about. And it's a place where you can go and get some support, and usually a lot of bad advice from the people that go on, and then I go in and correct it. So always remember.
We'll be sharing all of these slides we'll be sharing them with the healthy babies, and I think they'll share them out. Thank you so much for attending, y'all.
Yes,
we'll
absolutely.
see you in the next series.
Thank
Sorry,
you.
so rushed.
Okay, bye-bye.